If you get sued for debt, you can tell your side of the story and present defenses on your answer form. This video explains what these defenses are and how you can challenge creditors and debt collectors in court and win. My name is Ben, and I work for the nonprofit Upsolve. We help people get out of debt and take control of their finances. You can learn more about Upsolve in the link in the description. Let's get into it. Defensive versus affirmative defenses. What's the difference? When you raise a defense, you're disputing a claim or multiple claims that the plaintiff raised in their complaint. Now remember, the complaint is the court document that explains why you're being sued. This is part of the admit, deny, or I don't have enough information process that we covered in our video of how to fill out an answer form in a debt collection lawsuit. An affirmative defense is slightly different. With an affirmative defense, you're telling the court that there's relevant information that the debt collector left out of their complaint. You're also telling the court that in light of this information, you should win the case. Now let's run through a hypothetical example for each type of defense. Let's say that Collections Incorporated sues you for $1,000 for a credit card bill that they say you didn't pay, but you actually have proof that you paid that credit card bill last year. You can use that as a defense. This would actually be considered a strong defense if you have proof that you actually paid that credit card bill. Here are some other common defenses in a debt collection lawsuit. Number one, the debt isn't actually yours. This could be the result of identity theft or because the debt collector actually misidentified the account holder, which does happen. It can be hard to prove sometimes, but you can actually press the debt collector to prove that you were the one responsible for the debt. The second most common defense is that the amount of the debt is just wrong. Whenever you're directly challenging the accuracy of a claim that the plaintiff made in their complaint, that's a defense. Okay, now let's say that Collections Incorporated sues you for $1,000 for a credit card bill debt that they say that you didn't pay 10 years ago. In this case, you can say that you actually did owe that $1,000, but that because it's been 10 years, it's past the statute of limitations for your state, and the debt collector is actually not legally allowed to sue you. Whenever someone is suing you for a debt and it's past the statute of limitations in your state, you can raise that as an affirmative defense. And this affirmative defense is actually quite common in debt collection lawsuits. But it can get a little complicated because the statute of limitations are different in every state for each different type of debt. You can learn more about the laws in your state by checking out the link in the description below. Now, it might seem a little bit strange to admit that what the debt collector is saying is true, while also asking the court to let you off the hook. And that's exactly what you're doing in an affirmative defense. But there's actually quite a few affirmative defenses that can really help you in your debt collection lawsuit. That's because when debt collectors send in a complaint, they're only telling their side of the story, but they may not actually be telling all of the facts in their side of the story because they either know that they messed up or they just don't have all of those facts. An affirmative defense helps you set the record straight and tell the whole story. Here's a quick explanation of some of the most common affirmative defenses that might apply in a debt collection lawsuit. First, maybe the debt collector harassed or deceived you while trying to collect the debt, and that violates your rights under the Fair Debt Collection Practices Act. You can learn more about your rights under the Fair Debt Collection Practices Act, also called the FDCPA, in the link in the description below. The second most common is that the debt was actually discharged during bankruptcy, and the debt collector is no longer allowed to sue you for that debt. The third is that the debt is too old to be collected. This is the statute of limitations defense that we mentioned earlier. The fourth most common affirmative defense is that the debt collector didn't properly serve the court documents to you, or that they violated some other court rule. Now, the requirements that the court has vary by state, so you'll need to know whether this affirmative defense actually applies in your specific case. You can learn more about the rules in your state at the link in the description below. The bottom line is that every case is different. If you're not sure how these defenses apply in your case, or if you just want some additional legal help, check out the link in the description below for access to free or low-cost attorneys near you. You can also check out upsolve.org to learn more about your rights in the debt collection process and to see if you're eligible for our free help.